No. Judge, may it please the court? Counsel, exactly what you want after 3 hours of hearing lawyers is 15 more minutes of a lawyer. But I do get the last chance because we do have the burden of proof and we accept it. We've accepted it from the day we got together to determine who could actually sit here for 3 weeks and did the hardship. The burden of proof, by the way, is greater weight of the evidence, and I'm going to disagree as much as I respect my partner, Mr. Vogt. It's not 51-49. Literally, you know, the example generally used is scales. And if you had 100 beans or anything on one side and 100 on the other, and you were to take one and move it, that's greater weight. It's that simple. That's our burden. We've accepted it from day one, and do not give him sympathy. We're not here for sympathy. This isn't about sympathy. If you find that they victimized him as part of the facts here, that's part of the drama of a case, okay? But we don't want sympathy because the law is why Mr. Balea has been here from day one. And what I found remarkably interesting is noble as Mr. Sullivan's discussion of civics in our government and the protection of speech was, what he left out was the fact that this case is not about the protection of political speech or someone's right to be a neo-Nazi or burn a flag. That's a different part of the First Amendment. This case, and what makes it unique for you as the fact finders, is because it's a balancing case between another right that he didn't talk about in his hour and a half, which was the right to privacy. When he talked to you about what he liked to call this legitimate business concern, newsworthy business, as he said, he left this part out. Because at the end of the day, what you're doing here is not saying we hate the First Amendment or like the First Amendment, and you're not condemning someone's right to engage in politically charged speech or speech that may be unpopular. We all get that. What you're doing in this case is balancing someone's right to make that speech with the right to privacy. That's what it's always been about. They don't talk about that because his client doesn't think the right to privacy exists, which is why we're here to begin with. So let's get it back to point one. And the whole idea that the reason why Gawker exists is to do things that aren't First Amendment protected, but fail this balancing test. So I want to take you back to this, because this is the end of your instruction on legitimate public concern, which is the First Amendment defense. In weighing this issue, you should take into account the content, context, and form. By the way, parenthetically, when Mr. Sullivan talked about this, he left out the word content and talked about context. Of the material at the time of publication to determine whether it relates to a matter of public concern. The line between the right to privacy and the freedom of the press is drawn where the publication ceases to be given titled and becomes a morbid and sensational prying into private lives for its own sake, with which a reasonable member of the public, by the way, he also misspoke about that standard. It's not what a celebrity deals with data. It's what a reasonable member of the public would tolerate. That's you. With decent standards would say that he or she had no concern, which goes back to the simple premise that the fact that a celebrity, whether it be Mr. Balea or Jennifer Garner or Ben Affleck or Matt Damon or Captain Kangaroo or an athlete, whether they talk about their sex life in interviews does not give anyone the right to go into a bedroom with a camera, take pictures of them having sex, and then put it on the internet under the guise of newsworthy. That's the issue. And if you're offended by the fact that Mr. Balea went on these shock jock shows, look, we've gone over it time and time again. It's a demographic that wrestling audiences listen to. You go on the show at your own risk and you have no control. And yes, it's raunchy. It does not open the door to putting a camera in a bedroom and putting that on the internet. And I found it interesting that they made this argument. By the way, this whole idea, this First Amendment thing that Mr. Sullivan just went through in this sort of reminder of our civics lessons in high school, loses sight of the fact that his own client has said, we are journalists. I think what he said at one point is journalism's good. They have to do this. But then his client has said under oath and in articles, we're not journalists. If we inadvertently commit journalism, that may happen, we may do good, but we don't seek to do good. So they don't even fall into the category that he's trying to protect. But what I found amazing was this idea that because 9 seconds were put up there, it wasn't bad enough. For instance, we broke the law, but we didn't break it bad enough, or we could have broken it worse. We hurt him, but we didn't hurt him as bad as we could have if we had put all 30 minutes up. You know, so what I find hilarious is that he started his argument with the idea that we didn't put the sex tape on in evidence. We've been enforcing a privacy right for 3.5 years. The whole premise of this is not to publish this thing. The whole idea is we don't think people have the right to see Mr. Bollea in a private bedroom. That's it. So you need to question, as the fact finder and the quote editor, according to Mr. Sullivan, when you go back there, why didn't the guy who's protecting the First Amendment play the video they're so proud of in court? They're the ones who say free information, everybody find out, go back to civics. They could have played it. It would be completely inconsistent with everything we've been trying to tell you for us to play. If you want to watch it, watch it. He described it. You're right, there's 9 seconds. That, according to Mr. Denton, will stand the test of time. Remember that? Because they're out there forever. We did some very remedial math on that. And if I can find the sheet on it, it was like the 9 seconds times the number of hits. I wrote it down. Here we go. 9 seconds times 7,057,241 views equals 63,515,169 seconds, 17,143 hours, and 700, I think, 35 or 75 days that Mr. Bollea was seen naked on the internet in this excerpt. So if you buy the "we hurt them but not bad enough" argument, you know, try and quantify it, and it's still out there forever. The reason why the Pornhub guy, by the way, goes out there and says it's available for free is those celebrities are like Kardashian. They controlled it. They sold it. It was licensed. It's different. They got paid money for it, and it just goes out there. This one was out there because of Gawker. It wasn't knowingly made or consented to. And by the way, Anderson's testimony, just while we're on that, he said unique viewers. Denton says unique views and page views go hand in hand. They're like the same thing. The reason why he's never valued a business like this before is it's pretty unique when one thing drives that much traffic. And if you go to Mia Livy, she conceded on across the same thing every one of them said, which was this idea that they have to have traffic to get ads. Pull up the Facebook shot, because this is another thing they've done throughout this case. Look at the date on this Facebook screenshot. Look at the date. October, this is the date it was posted. This is when the screenshots were. It's not after the 735 days that the 9 seconds cumulatively was published. And they tell you this and go, oh, look at their viral marketing. This is what they mean. This, who knows what time, because there's no timestamp on it. And by the way, while we're at it, Hulk Hogan's sex tape is the heavyweights champion of sex tapes. Delario's words, you know. I'm not going to get into the first 30 minutes of his closing. If we have the board again, I'm not going to, you get it, you have to get it at this point. Everything they say that made this newsworthy was not discussed in the article. Here, we don't have to do it. They've seen it. I'm going to grab it. Let me see it. Yeah, actually stand. Look at this. I mean, this is sort of the ultimate in sort of, you know, well, yeah, the lawyers got involved and we said this is why it's newsworthy. And you know, it's like we weren't nitpicking. I mean, I don't even know how he could say that. Mr. Vogt went down. These are the reasons they give. That's what you do in law. You say, okay, you say it's newsworthy because his erect penis was there, the existence of the tape. He never denied the tape existed, the hypocrisy, none of this. Every single one, that's what you do. You ask them, well, here's what your defense is. You say it's newsworthy for these reasons. Was it newsworthy for that reason, Mr. Delario? You were the editor, you wrote it. No. You know, I mean, it's a very transparent exercise. You don't get to come back after the fact and says, well, it was just newsworthy then. That's what, you don't do that. It doesn't work that way. And the idea about the words, I thought I made this clear, and maybe Mr. Sullivan was trying to disagree with me but didn't. We're not suing on the words. The law tells you have to look at the content and the context and the form of the video, which takes me to, if 59. So the reason you look at the words is because it tells you what he was thinking. That tells you why he's publishing the tape, the content, and the context. So what does it tell you? Does it tell you he wanted to talk about Terry Bollea going on about his sex life on a shock jock show? I mean, no! It's just porn. And the First Amendment may protect the right for pornographers to put porn out there, but not when you balance it against the right to privacy. That's the difference here. That they don't want you to think about, because this client doesn't think anybody's private anywhere ever. You're on Facebook, you're not private. That's Nick Denton. All right? This is something we got here on Denton's Cross, right? Make the story support the image. Gratuitous. Like one of you asked at some point. You didn't need the video for him to say, well, I watched the video and here's what it said. It was gratuitous. It wasn't needed. There was no denial the tape existed. He just puts it out there because more people click on it when it happens. So, you know, that's the point about the words. I'm going to go through a few more of these. You talk about the Hail Mary of Hail Marys. This was a 5-year scheme, or 3.5-year scheme. A lawsuit was filed in 2012 because it's a, quote, work, and the whole thing is a scheme. You want to go back and listen to Heather Clem. The one thing Heather Clem says, and by the way, Mr. Sullivan didn't say this either. 2 people didn't know about it. 3 people did. That's what Barry said on Hogan. Mr. Barry said that. Of those 3, you heard from 2. You heard from Mr. Bollea, you heard from Ms. Clem. Ms. Clem said Mr. Bollea did not know he was being recorded. That's it. That's what we have. He also said that Mr. Bollea said he knew there was a secret camera in the bedroom, which he just didn't say. That's nowhere in evidence in this case. I mean, that, like, to me, was just almost like made up. It's just not there. So the dirty, the TMC, we've been through this. This is kind of funny because at one point they say he seeks your sympathy and wants you to feel bad for him, and he doesn't have thin skin, or he has thin skin. The dirty and the TMZ never, how much more do I have to? 5? The dirty and the TMZ never put the tape out. Doesn't that tell you something? They never even published the 9-second excerpt or 1:41. Doesn't that tell you something? Don't forget the fact also that the screenshots they put up were taken down. And don't forget the fact also that that's all they put up in a story about the existence of the sex tape, which Mr. Bollea always acknowledged, and we've never contested about its existence. I think that, surprisingly, that may be all I have to talk to you all about. What's that? The press conference. This press conference. I'm not going to talk. I don't know what the deal was with the press conference and their problems with it. They got out there, Mr. Houston, Mr. Harder, they announced that there was a lawsuit, and they were out there to seek, you know, everybody else to know about it. You know, I don't know why they've made a big deal about it. I think that their theory there is that once he found out his rights got violated, that trying to stop other people from doing it was a bad thing. And, you know, look at Ms. Traub's Send It to Entertainment Journals. Those are the kind of people that follow professional wrestlers. So I guess at the end of the day, you know, when we look at this and we try and figure out together, you know, how it all fits. I go back to sort of the simple concept that we started it with, and it's funny how lawyers like to say that, we start where we end and all these things we say. But their motive in this was profit. I mean, plain and simple. It was traffic. It was to put something out there that no one else had, so they could get traffic, and then they could use that traffic to better their brand. And it's so easy to see that common thread through every single thing that they talked about in this case, because it always came back to somebody conceding that traffic is what they wanted, and this got them traffic. You know, you look at the numbers, and you know, they didn't talk a lot about the numbers. I was kind of interested in their closing as much as they did during the case. But if you look at the numbers in the realm of what their benefit was to their brand and to their growth, and I don't know why they're denying their brand grew, because they had this 3 years of increasing revenue, would have been to Mr. Bollea vis-a-vis other sources and the Gawker actual watches of the video, the $7 million number. In their world, it's reasonable. In their world, that's what they bought back in 2012 when they refused to respond to Mr. Houston's cease and desist letter and found it not persuasive. So that's really, all I have vis-a-vis rebuttal on this. I want to thank you all for your time. This is going to go back with you, and if I can remind you of one simple premise and one simple idea. Look, we didn't create this world. This could have ended when Mr. Houston sent that cease and desist. But don't lose sight of the fact that this isn't a civic lessons in unpopular speech, okay? This is a balancing between two sacred rights, the right of privacy and the First Amendment right. The judge has instructed you on the law. It's not the law of the land or what we all want to do. It's what she gave you, what she read to you in that balancing test. So please, when you go back there, go through that and please enter a verdict on behalf of Mr. Bolea. Thank you.
Do not do any research on your own or as a group. Do not use dictionaries, the internet, or any other reference materials. Do not investigate the case or conduct any experiments. Do not visit or view the scene of any event involved in this case or look at any maps or pictures on the hear the same evidence at the same time. Do not read, listen to, or watch any news accounts of this trial. You are not to communicate with any person outside the jury about this case until you have reached a verdict. You must not talk about this case in person or through the telephone, writing, or in electronic communication such as a blog, Twitter, email, text message, or any other means. Do not contact anyone to assist you, such as a family accountant, a doctor, or lawyer. These communications apply until I discharge you at the end of the case. If you become aware of any violation of these instructions or any other instruction that I have given you in this case, you must tell me by giving a note to the deputy. Any notes that you have taken during the trial may be taken to the jury room for use during your discussions. Your notes are simply an aid to your own memory, and neither your notes nor those of any other juror are binding or conclusive. Your note or that of other jurors. Instead, your verdict must result from the collective memory and judgment of all jurors based on the evidence and testimony presented during the trial. At the conclusion of the trial, the deputy will collect all of your notes and they will immediately be destroyed. No one will ever read your notes and personally shred them. In reaching your verdict, please do not let bias, sympathy, prejudice, public opinion, or any other sentiment for or against any party to influence your decision. Your verdict must be based on the evidence that has been received and the law on which I've instructed you. Reaching a verdict is exclusively your job. I cannot participate in that decision in any way, and you should not guess what I think your verdict should be from something that I may have said or done. You should not think that I prefer one verdict over another. Therefore, in reaching a verdict, you should not consider anything that I have said or done except for my specific instructions to you. Pay careful attention to all of the instructions that I gave you, for that is the law that you must follow. You each have a copy of these instructions with you when you go back to the jury room to deliberate. All of the instructions are important, and you must first consider all of them together. There are no other laws that apply to this case, and if you do not agree with these laws, you must use. When you go to the jury room, the first thing that you should do is choose a presiding juror to act as the foreperson during your deliberations. The fourth orderly, and that everyone has a fair chance to be heard. It is your duty now to talk with one another in the jury room and to consider the views of all of the jurors. Each of you must decide this case for yourself, but only after you have considered the evidence of the other members of the jury. Feel free to change your mind if you are not different. You should all try to agree just because others think differently. Keep an open mind. Please share ideas about the case. I will give you a verdict form with questions that you must answer. I have already used in answering these questions. You must follow my instructions and the form carefully. You must and please answer the questions in the order they appear. After you answer a question, the form tells you what to do next, and I will now read the form to you. Professionally known as Hogan. You don't have that with you. You'll get one. Professionally known as Hogan as the plaintiff versus Gawker Media LLC, also known as Gawker Media, Nick Denton, AJ Delario, defendants. Verdict. We, the jury, return the following verdict. First claim, publication of private facts. 1. Did the plaintiff prove that by posting the video, defendants publicly disclosed private facts about plaintiff in a manner that a reasonable person would find highly offensive? Yes or no? If your answer is yes, please answer question 2. If your answer is no, then your verdict is against the plaintiff on claim for publication of private facts. You should proceed to question 3. Question 2. Did the plaintiff prove that the video was not a matter of legitimate public concern, yes or no? If you answered yes to questions 1 and 2, then your verdict on the claim of publication of private facts is in favor of plaintiff. Please proceed to question 3. If you answered no to question 2, then your verdict is against plaintiff on all of his claims and in favor of defendants on their First Amendment defense, and your deliberations are over, and you will not consider any further claims or damages. You should only sign this verdict form and return it to the courtroom. Number 3, did Nick Denton participate in the posting of the video on Gawker.com? Yes or no? And then please proceed to question 4. The second claim, invasion of privacy based on intrusion. Number 4. Did the plaintiff prove that defendants wrongfully intruded into a place where he had a reasonable expectation of privacy? Yes or no? If your answer is yes, please answer question 5. If your answer is no, then your verdict is against the plaintiff on his claim for invasion of privacy based on intrusion, and you should proceed to question 6. Question 5, did plaintiff prove that the video was posted in such a manner as to outrage or cause mental suffering, shame, or humiliation to a person of ordinary sensibilities? Yes or no? If you answered yes to questions 4 and 5, then your verdict on the claim of invasion of privacy based on intrusion is in favor of plaintiff. If you answered no to question 5, then your verdict is against plaintiff on his claim for invasion of privacy based on intrusion. And please proceed to question 6. Third claim, violation of Florida common law right of publicity. Number 6. Did plaintiff prove that defendants used plaintiff's name or likeness for a commercial or advertising purpose? Yes or no? If your answer is yes, please answer question 7. If your answer is no, then your verdict is against plaintiff on his claim for violation of Florida common law right of publicity, and you should proceed to question 8. Number 7. Did the plaintiff prove that he did not authorize the use of his name or likeness? Yes or no? If you answered yes to questions 6 and 7, then your verdict on the claim of violation of Florida common law right of publicity is in favor of plaintiff, and you should proceed to question 8. If you answered no to question 7, then your verdict is against plaintiff on claim for violation of Florida common law right of publicity. Please answer question 8. Fourth claim, intentional infliction of emotional distress. Number 8. Did plaintiff prove that posting the video was extreme and outrageous to a person of ordinary sensibilities? Yes or no? If your answer is yes, please answer question 9. If your answer is no, then your verdict on plaintiff's claim for intentional infliction of emotional distress is against the plaintiff, and you should proceed to question 11. Question 9. Did the plaintiff prove that defendants intended to cause him severe emotional distress or acted with reckless disregard of the high probability of causing him severe emotional distress? Yes or no? If your answer is yes, please answer question 10. If your answer is no, then your verdict on plaintiff's claim for intentional infliction of emotional distress is against the plaintiff, and you should proceed to question 11. Number 10, did the plaintiff prove that the posting of the video caused him severe emotional distress? Yes or no? If you answered yes to questions 8 through 10, then your verdict on the claim of intentional infliction of emotional distress is in favor of the plaintiff. Please proceed to question 11. If you answered no to question 10, then your verdict is against the plaintiff on his claim for intentional infliction of emotional distress. Please proceed to question 11. The fifth claim, violation of Florida Security of Communications Act. Did the plaintiff prove that the defendants intentionally used or disclosed the video? Yes or no? If your answer is yes, please answer question 12. If your answer is no, then your verdict on plaintiff's claim for violation of Florida Security of Communications Act is against the plaintiff, and you should proceed to question 15. Number 12, did the plaintiff prove that he had a reasonable expectation of privacy in the bedroom where the video was recorded? Yes or no? If your answer is yes, please answer question 13. If your answer is no, then your verdict on plaintiff's claim for violation of Florida Security of Communications Act is against the plaintiff, and you should proceed to question 15. Number 13, did the plaintiff prove that defendants knew or had reason to know that he was recorded on the video without his consent or without his knowledge or consent? Yes or no? If your answer is yes to questions 11 through 13, then your verdict on plaintiff's claim for violation of Florida Security of Communications Act is in favor of plaintiff, and you should proceed to question 14 to consider defendant's good faith defense. If your answer to question 13 is no, then your verdict on plaintiff's claim for violation of Florida Security of Communications Act is against plaintiff, and you should proceed to the damages instruction paragraph before question 15. The good faith defense. Number 14, as to only plaintiff's claim for violation of Florida Security of Communications Act, did defendants prove that they acted in good faith reliance on a good faith determination that their conduct was lawful? Yes or no? If your answer to question 14 is yes, then your verdict on plaintiff's claim for violation of Florida Security of Communications Act is in favor of defendants. If your answer to question 14 is no, then your verdict on defendant's good faith defense is against defendants and in favor of plaintiff on his claim for violation of Florida Security of Communications Act. The damages introduction. If your verdict was in favor of plaintiff on his claims for publication of private facts, yes to questions 1 and 2. Invasion of privacy or intrusion, yes to questions 4 and 5. Violation of common law right to publicity, yes to questions 6 and 7. Intentional infliction of emotional distress, yes to questions 8 and 10. 8 through 10, and or a violation of Florida Security of Communications Act, yes to questions 11 through 13. You consider the matter of damages and should proceed to question 15. Question 15 on damages. A, what is the total amount of money that will fairly and adequately compensate plaintiff for any economic injuries, losses, or damages caused by the defendant's conduct. There's a dollar sign and a line. And then B, what is the total amount of money that would fairly and adequately compensate Jerry DeLeo for the emotional distress which resulted from the defendant's posting the video on the internet? And there's a dollar sign and a line. The total damages of plaintiff, add lines 15A and 15B above, and a dollar sign and a line. Please proceed to punitive damages. Punitive damages. Number 16, under the circumstances of this case, state whether you find by clear and convincing evidence that punitive damages are warranted against Gawker Media, LLC, yes or no, Nick Denton, yes or no, AJ Delirio, yes or no. If you answered yes for any defendant, please answer question 17 as to that or those defendants. If you answered no as to all defendants, please sign and date this verdict form and return it to the courtroom. Did defendants have number 17, did defendants have a specific intent to harm the plaintiff when they posted the video on the internet? Gawker Media, LLC, yes or no? Nick Denton, yes or no? AJ Delirio, yes or no? Please sign and date this verdict form and return it to the courtroom. So say we all, this blank day, which today is the 18th day of March 2016, and there's a line in for the signature of the foreperson. Your verdict must be unanimous. That is, your verdict must be agreed to by each of you. When you have agreed on your verdict and finished filling out the form, the foreperson must write the date, March 18th, 2016, and sign it at the bottom and return the verdict to the deputy. You'll knock on the door to let the deputy know that you've concluded your deliberations. If any of you need to communicate with me for any reason, please write a note, knock on the door, and give it to the deputy. Please do not disclose any kind of vote or split or the reason for the communication. So at this point in time, I do have the responsibility to tell 3 of you that you are our alternates. So number 7, 8, and 9, you are our alternates. We do not tell people who the alternates are in these cases because, especially in long trials such as this, it's very common for one of the other jurors to have some kind of a personal issue where they need to leave the courtroom, and then we exercise one of our alternates. So for the alternates, I would like you to stay behind or collect any, you can collect any of your personal belongings in the jury room, of course, and then come back to the courtroom. For the remainder of you, at this point, you may now retire to deliberate and will await your verdict. The first thing you're going to do back there is Deputy Hernandez is going to give you some menus so that you can order lunch, so we can get the lunch being processed so you'll be eating your lunch while you deliberate. We'll have it delivered to the jury room. All the evidence will be brought back to you, and the verdict form will be delivered back into it. So we will await your return. Thank you all so very much.
Both of you.